In a bold move, a federal judge has put a halt to the Trump administration's sweeping exemptions to the birth control mandate, a provision of the Affordable Care Act that requires all employer health plans to cover contraception at no cost. This decision has stirred up a hornet's nest of controversy, with implications that reach far beyond the courtroom. Let's dive into the details and see why this ruling has everyone talking. On Wednesday, District Judge Wendy Beetlestone of Philadelphia issued a summary judgment declaring that the rules were arbitrary, capricious, and an overreach of the authority of the agencies that penned them in 2017. The Trump administration's religious and moral carve-outs to the birth control mandate allowed essentially any for-profit or non-profit employer or insurer to exempt themselves from providing contraception coverage on moral and religious grounds. Publicly traded companies were also granted a religious exemption, but not a moral one. But here's where it gets controversial. The Affordable Care Act required employer health plans to cover at least one of 18 forms of birth control approved by the Food and Drug Administration. Religious groups and employers took legal action, and in 2014, the Supreme Court ruled 5-4 that the contraceptive mandate violated the Religious Freedom Restoration Act, RFRA, rights of closely held corporations whose owners had religious objections. The Trump administration's blanket exemption in 2017 was an attempt to find a balance, but it sparked a new round of lawsuits. And this is the part most people miss. Pennsylvania, New Jersey, and dozens of other states sued to halt the broad expansion of exemptions and accommodations. The case reached the Supreme Court in 2020, where the justices upheld the Trump rules on technical grounds, but did not address the underlying merits of the case. The case was sent back to the lower court, where a religious group, the Little Sisters of the Poor, joined the lawsuit alongside the federal government in asking for summary judgment. Judge Beetlestone, an appointee of former President Obama, wrote that the Trump administration's religious rule did not accomplish what the agencies purportedly wrote it to do, which was to resolve a conflict between the contraceptive mandate and RFRA. The rule exemptions to organizations that are unlikely, if ever, to be capable of maintaining a religious objection raised doubts about the rational connection between the rule and remedying potential conflicts with RFRA. The Little Sisters of the Poor, represented by the Becket Fund for Religious Liberty, a nonprofit, will appeal the ruling in the coming weeks. This decision has set the stage for a legal battle that could have far-reaching consequences for religious freedom and women's health rights. What do you think about this ruling? Do you agree with Judge Beetlestone's decision, or do you believe that the Trump administration's exemptions were justified? Share your thoughts in the comments below.